How do IP rights conflict with data privacy laws? Imagine a world where protecting your inventions and safeguarding your personal information are at odds. That's the challenge many tech companies face today. When companies develop new software or hardware, they often rely on collecting and analyzing large amounts of data. This data helps improve products and protect intellectual property rights. But at the same time, data privacy laws are designed to keep personal information safe and limit how data is used or shared. Intellectual property rights give creators control over their inventions, trademarks, or creative works. They want to use data to develop, protect, and enforce their innovations. For example, a company might use personal data to train an artificial intelligence system or to improve a product. However, data privacy laws restrict how personal data can be collected and used without explicit consent. This means that even if a company owns the rights to a database or software, they still need to follow privacy rules when handling personal information. One big issue is ownership versus privacy. Intellectual property rights give companies control over database assets like software or databases. But privacy laws focus on giving individuals control over their personal data. This can create conflicts when a company needs personal data to protect its IP. For example, tracking unauthorized use of copyrighted material online might requiring accessing personal user information. Privacy laws may prevent or limit this access, making enforcement more difficult. Another challenge is international differences. Countries have different rules for intellectual property and data privacy. When data crosses borders, conflicts can happen. A company might have strong IP protections in one country but face strict privacy restrictions in another. This makes managing global IP portfolios complicated, especially in the tech sector where data flows freely across borders. Balancing the need for innovation with privacy protection is key. Overly strict IP enforcement can slow down the sharing of information needed for new inventions. On the other hand, strong privacy laws can limit access to data necessary for developing new technologies. Companies need to find ways to comply with privacy laws while still protecting their IP rights. Practical solutions include anonymizing personal data to remove identifiers, so it can be used for innovation without privacy violations. Licensing agreements can specify how data is shared and protected, ensuring both IP rights and privacy are respected. Developing internal policies and using technology to ensure compliance helps companies stay within legal boundaries. International cooperation and harmonizing legal standards can also reduce conflicts, making it easier to manage IP and privacy across different regions. In managing intellectual property portfolios in the tech world, understanding these conflicts is vital. Companies must carefully evaluate privacy risks when using data for innovation. They should enforce IP rights in ways that respect privacy laws, protecting their inventions while safeguarding individuals' personal information. This careful balance helps foster innovation without sacrificing privacy.